$1,699 monthly is at stake if your VA DIC remarriage date is wrong. Professor Ferreira studies survivor eligibility and the date rules that make this issue look contradictory. The rule isn't one age for every remarriage. It depends on which remarriage happened when. Stay with us because the restoration route later is where the costliest planning mistake hides.
Here's who the newer remarriage rule hits. A surviving spouse planning a wedding while protecting the monthly DIC deposit that keeps housing, medication, and groceries steady. They're not studying a statute for fun.
History's verdict is why both numbers survive. The older rule came first, the newer rule followed. We already ran the experiment where one age kept circulating after the law added another.
Here's the sequence. First, identify the remarriage date. Second, identify the survivor's age on that date. Only after that do you decide whether the newer or 2003 pathway answers the question.
For the historical route, the exception uses age 57. For a remarriage on or after January 5, 2021, VA says a surviving spouse may receive or continue DIC when the spouse was 55 or older. Federal law states that this age doesn't bar Chapter 13 DIC.
So if someone is 56 today, the useful question isn't, did I pass some universal birthday? It is, what date will I remarry and which published VA rule covers that date?
Precisely. A screenshot with the earlier number can be historically accurate and still be incomplete for a remarriage happening now.
Before any ceremony, verify the published money too. The basic surviving spouse DIC rate became effective December 1, 2025. It is $1,699.36 per month. Add-ons can change an individual amount, but that's the base figure we're protecting in this episode.
And age alone should never be used as a blanket promise. You qualify only if you are otherwise the eligible surviving spouse and the remarriage facts fit the applicable dated rule. The exception preserves eligibility, it doesn't manufacture it.
Picture Maria. She is 56, already receiving DIC and planning a fall wedding. Her safest move is to take the wedding date and her birth date to an accredited representative. She also brings her latest DIC notice before deposits and invitations harden into decisions.
A wedding has a date, benefits law has dates. Pretending either one is approximate is how expensive surprises begin.
Coming up, we'll separate DIC from the exception, then expose the restoration trap that can turn may return into will return. One thing before the next part, and then we move right on. If any of this is clicking, tap that like, hit subscribe, and ring the bell for the next one. It takes a second, it costs nothing, and it helps more than you would think.
Before we argue about keeping the base DIC payment, let's name the thing being kept. Dependency and indemnity compensation is a survivor benefit. It isn't the veteran's disability check continuing under a different name.
That paperwork distinction is the first file tab. Put the latest DIC notice, the surviving spouse's identity record, and the marriage timeline together before anyone tries to conclude from memory.
DIC isn't the veteran's old check. The published base is $1,699.36 each month. Additions are separate.
Which means two survivors can both be eligible and still see different deposits. One may have a qualifying child or another applicable addition. We are using the base rate so the remarriage rule doesn't get tangled with somebody else's household.
Bella was right to separate DIC from the veteran's old check. Professor Ferreira's warning from the desk matters here. The remarriage exception preserves an existing legal relationship to DIC. It doesn't prove the death-related eligibility requirements by itself. Lewis, which total on that notice is bothering you?
Which number on the award letter is the DIC payment? Some letters show 3 totals.
Good repair. Use the actual DIC deposit and the effective date on the latest notice. Individual add-ons can change that amount. Compare it with the official VA rate table, not a veteran-alone disability chart.
That is the human version of due diligence. You are not trying to turn a wedding into a claims seminar. You are giving yourself one calm hour now so the family budget doesn't have to absorb a preventable shock later.
One calm hour is cheaper than 1 year of confusion.
Keep the published rate in perspective. This is household money, not a technical footnote. That's why a one-line internet claim deserves a real source check.
Keep the DIC notice and identity records together. Then take that packet to an informed helper. That annual base is rent, utilities, and breathing room. The survivor asking this question isn't being unromantic. They are doing responsible household planning.
And no, the published figure isn't a promise that every add-on remains unchanged. Check the actual notice. We are protecting precision, not selling reassurance.
Now we can resolve the number conflict cleanly. 2 thresholds appear because Congress and VA built 2 dated doors, not because one website forgot the rule. Professor Ferreira, back with us for the calendar. Why can 2 remarriage pathways show different ages without either page being wrong?
Because the provisions attach to different remarriage dates. The page is preserving both legal histories, and a reader who skips the date clause sees only competing ages.
The older path begins with remarriages on or after December 16, 2003. That language pairs with age 57 or above at remarriage.
Then came January 5th, 2021. VA states age 55 or older.
So the calendar isn't decoration. It is the first branch in the decision tree. If we don't know when the remarriage occurred, the age analysis is unfinished.
Exactly, existing DIC status comes last because the ages aren't interchangeable. The law in force says remarriage after age 55 doesn't bar Chapter 13 DIC. VA guidance keeps the historical route because some claims predate the newer provision. Start with legal history and remarriage date, then check age on that date. Reverse the order and a true number can reach the wrong survivor.
Let me test it with Maria. She is 56 and plans to remarry this year. She doesn't have to wait for the earlier age merely because a legacy article cites it, provided her eligibility and facts fit the applicable path.
Provided is the hinge. This shortcut can't decide a pre-change case.
Before we leave the pre-change cases, what about someone who remarried years ago at 56, before the newer date?
That person shouldn't project today's newer path backward without a case-specific review. New remarriages should be checked under the law in force. For a historical case, the remarriage date and the age on that date matter. So do the claim status and any later marital status change.
That is much better guidance than telling a survivor, you're past the newer age, so you're fine. It gives them the facts to gather without pretending the record has already been reviewed.
My allotment runs on seasons. This rule runs on effective dates. Ignore the calendar and the result changes.
Professor Ferreira, keep one sentence for the viewer.
Use the newer age rule for a new remarriage only after you verify that path fits your record. Use age 57 when the prior dated route is the one your facts invoke.
That settles the age conflict. Next comes the harder case. What happens when the remarriage took place before the protected age?
The hardest version of this question is the survivor who isn't yet within the protected age pathway. That is where a comforting shortcut can do the most damage.
A benefits status letter may be the first sign that VA sees the marital change differently. Do not wait for that letter to learn the sequence.
Outside a statutory exception, remarriage can bar DIC. Don't build a plan around possible restoration later.
Because planning around a future divorce or a future death isn't a plan. It is a family crisis drafted in advance, and nobody deserves that sales pitch.
The restoration branch is real but conditional. Section 103 includes subsection D and paragraph 2. It says benefits may be furnished again after a remarriage ends by death or divorce, subject to the rules. But may be furnished again is
Not automatic. Fraud or collusion can still block restoration.
correct. Restoration still depends on the governing rules. The survivor needs the record reviewed and the appropriate claim action taken. A statute creates the route. It doesn't promise that every file updates without evidence or process.
The practical checklist is gentle but firm. Confirm the survivor's age on the remarriage date. Confirm which dated pathway applies. Then ask what the present marriage or its termination did to the actual DIC status.
My family's wall calendar is the house's central nervous system. This file needs the same discipline: every marriage, birthday, and termination date in one sequence.
People turn can into will, then budget against the stronger verb.
The better language is there may be a restoration route. Bring the marriage record and the record showing how that marriage ended. Let the accredited reviewer match those facts to the law in force.
And put the dates in order: original marriage to the veteran's death, later remarriage, and age on that remarriage date. Add any later death or divorce. Sequence first, conclusion second.
A missing decree can control the outcome.
So keep the warmth and lose the guesswork. A new marriage can be joyful and financially responsible at the same time. The responsible part is verifying DIC before the legal event.
Before we get to the claim form, we put the annual number on one page. The consequence should be visible before anyone dismisses this as a technical age rule. Now put the consequence in household terms. The monthly base DIC rate is $1,699.36. That isn't pocket change attached to a technical age rule. It can be the money that keeps rent, food, insurance, and utilities from competing with one another.
1 month makes the number feel manageable. 12 months show the decision. Multiply the monthly base by 12, and the annual base is $20,392.32.
Use the verified monthly base for this rate year. It became effective on December 1st of the prior year.
The second line is 12 payments. Nothing speculative is hiding there, but that base
Isn't every survivor's complete payment. Eligible survivors may receive add-ons including an 8-year provision or an allowance tied to aid and attendance. Those additions depend on facts we're not assuming here. That is why the receipt stops at the sourced base and doesn't invent a bigger household total.
Plan from the actual monthly total, never somebody else's add-on.
Bella, that correction changes the math. Use the amount on the latest notice and bank record. Then separate two questions. What does the law allow after the remarriage? What amount is actually at risk in this case? The legal conclusion and household total need to match.
Picture the decision at a kitchen table. One partner brings the wedding date. The survivor brings the DIC letter. They write down the age on that future date and the actual deposit. Suddenly, the conversation isn't a rumor about one birthday. It is a dated financial plan.
If it's unclear, write the question down for an accredited representative before the legal event.
The open question from the beginning was whether one birthday can protect a DIC check. Now the payoff is precise. The newer age rule can matter under its dated pathway, but the date and evidence decide whether that protection reaches DIC.
That annual figure is enough reason to replace a screenshot with documented guidance.
Next, the official form and the records that keep a correct decision moving.
Professor Ferreira, rejoin us for the paperwork. The viewer now knows the money and the two dated pathways. What should the survivor actually put in front of VA or an accredited representative?
Start with the official survivor claim form and the documents that establish the timeline. Mark each record as you find it. The goal isn't a thick folder, it is a file that lets the reviewer determine age, date, relationship, and DIC status without guessing.
The official application is VA Form 21P 534EZ. Mark that exact name on the checklist before filing so a search doesn't land on the wrong form.
Its official title covers dependency and indemnity compensation, survivor's pension and accrued benefits. Those are the three survivor benefit lanes named on the application. The official copy shows the August revision displayed on screen. That date is a practical check, not trivia. If an old download has lingered on a laptop, replace it with the issuer's newest copy before filing.
Be precise about what the form can do. It's an application for survivor benefits, not a blanket advance approval certificate for every future remarriage. A remarriage question still turns on the governing law and
The survivor's facts. Filing isn't the same as receiving a ruling.
correct. The form starts or supports the claim process. A case-specific determination comes from applying the governing rule to the evidence and the actual DIC history.
Build the record in order. Keep the veteran's death certificate and the marriage record. Add any later marriage certificate, plus the date of a planned remarriage if that's the question. Include the latest DIC notice. For a restoration issue, include the document showing how the later marriage ended.
Then add one page with the dates written in plain order. Reviewers can read certificates, but a clean timeline makes a missing fact obvious before the package leaves your hands.
If the survivor is planning rather than filing today, take that same packet to a VA-accredited representative. Ask a narrow question. Under the governing rule, would this remarriage date and this age affect this existing DIC payment?
A narrow written question is valuable because it exposes ambiguity. If the guidance starts drifting into a general lecture about all survivor programs, bring it back to the remarriage date, age on that date, and the existing DIC.
And save the response with the supporting records. A phone call may calm the room, but a documented explanation is easier to revisit when dates change, or another office reviews the file.
This is where bureaucracy is almost helpful. It makes everyone resolve the same stubborn questions: which person, which date, which age, and which payment.
Professor Ferreira, thank you for keeping the difference between a legal pathway and an automatic promise so clear.
Glad to help. A precise timeline protects the survivor better than a confident slogan.
We will close with 3 checks you can perform before a remarriage, because the best file is the one built while every option is still open. Here is the 3-check close. First, write the exact remarriage date, not the engagement date, not the month you started planning, and not an estimate. The legal event places the case on the earlier or newer pathway.
Second, write the survivor's age on that exact date. A birthday before the wedding can change the analysis. A birthday after it can't be moved backward because the money would be useful.
Third, identify the existing DIC amount and the case history behind it. Use the latest notice, the actual deposit, and any prior marital status decision. That is the file a reviewer must protect or explain.
Those checks solve the age number fight. The earlier route is the dated rule many survivors still see online. The newer route covers remarriages under the January 5th change on the board. One internet number can't
Choose the pathway. The survivor's date does. The survivor's date chooses it. That is why the correct conclusion isn't one universal age. Match the actual remarriage date and age to the governing law, then check the existing DIC.
Do that before the legal event, while the couple can still change the schedule, gather a missing record, or ask a better question. Afterward, the same facts may describe a consequence instead of a choice.
The money hook was $1,699.36 a month. Here's what I'd actually do. Verify the dated route and evidence before the legal event, because only they can show whether DIC continues.
So put the 3 checks on one page and take that page, the DIC notice, and the supporting records to an accredited representative. Ask for guidance in terms of this date and this DIC.
That turns a frightening DIC rumor into a decision you can verify. The one rule to carry is this: the date chooses the pathway, and the file decides the DIC result.
Lewis, precision is the word. If this cleared up the age rule, subscribe and share it with a surviving spouse who has been told the earlier threshold is the only rule. Which fact will you verify first? Your age, remarriage date, or existing DIC amount? Bring the dates, protect the choices, and get the file reviewed before you remarry. I'm Nora. Thanks for watching.